Hey there, Attorney Joe Concepcion here again. Today I want to talk to you about a topic that's near and dear to me and so many other attorneys who have this argument, usually sitting at the jail with a client, who says, how did they charge me with burglary? I didn't break and enter, it wasn't that night. But Joe, you say, without these elements, it's not a burglary. How can they possibly charge me with this? Well, that's great if we were in King Henry's England. The definition of burglary, a common law which was developed in 12th century England and passed down by judicial decisions and respected by stare decisis, was that, yes, someone had to be breaking and entering. It was at night. But that was a long time ago, and that's the very first thing we learned in law school was common law, and then common law was superseded by penal codes. In 1962, the model penal code was developed. It was updated in 2000, I believe, 3. And the MPC has influenced state legislatures everywhere in terms of the laws that they've passed. And this is equally true in Florida, where the definition of a burglary is to enter or remain in a dwelling, a structure, or conveyance. What's a conveyance? It's a fancy word for a vehicle. To enter or remain in one of those places with the intent to commit an offense. Now, if I'm just trespassing, some homeless guy walks into my house, the door is open, and he takes up residence and sleeps there for the night, and then I find him, he's guilty of trespassing. Unless he was trying to steal stuff or commit some other offense, he's just trespassing. So a trespass plus the intent to commit an offense, now we've got a burglary. There's no breaking and entering or night involved. Where did night go? Well, it's not really said as night anymore, but there is an element to burglary that if the person attempts to enter the dwelling, structure, conveyance stealthily, then that will be evidence that's called prima facie evidence, or fancy word for I've heard enough. To assume that that is a burglary. In other words, somebody tries to enter trying not to be seen, it's going to be presumed, and they're doing it without the permission of the owner, it's presumed that they are trying to commit an offense. So, breaking and entering, night, there you have it. It's just not a thing. It might be a thing in some states. I know some statutes in other states have breaking and entering, but they also have the very basic definition of enter or remain to commit an offense. So as far as burglary is concerned, B&E, the element of night, all that is TV law. What do you think of that?